Welcome to the next lesson in Real Property 2. This is the next case in this series of adverse possession. We're going to dive right in. Let's get started. So this case is about a family who pulled off the cleanest land grab in history. They managed to lock down 36 acres of forest, and the courts backed them up 100%. No guns, no lawyers in suits, just straight up legal dominance. This is Paine versus Sexton, and it's how you turn paper, presence, and persistence into property. So here are the facts. In 1958, the Paine family starts running a campground in the middle of the woods, a 36-acre piece of land. So you got your tents, you got your little trees, a whole campground, 36 acres. And no one stopped them. They built campsites, they put up signs, they advertised it to the public. People come out, they camp, they hike, and they pay them. The Paines start making money off of this property. And this goes on for decades, into the 90s. Then the son keeps it going, he keeps the business running just like a boss. But then, something happens in 1999. In 1999, the Paines go, we're not just going to be acting like we own the 36 acres. We want to put it in writing. So what they do is they go to court to try to make this official. However, in 2007, Sexton, this lady, Sexton, strolls in, waving the deed, saying, wait, I own this land. So she comes over here telling them that she has some sort of writing that gives her priority over this land. But she's too late. The Paines didn't just rely on one way to win. They stacked the deck. They claimed adverse possession. Now, if you watch the previous video, you'll get a basic understanding of what adverse possession is. That's where you take land by using it so obviously and continuously that the real owner, in this case Sexton, loses their rights. And the Paines, they check every box. Now, in the previous video, if you were paying attention like you should, you would know that you need to check the box oceans. Now, off the top of your head, because you're so smart, what does oceans mean? It means open, continuous, exclusive, adversely, notorious, and bonus question. What does the S stand for? The S stands for the statutory period. If you meet all this criteria, you have adverse possession. But in addition to oceans, unlike the previous case in the gobbles, there's this new term that I'm going to go ahead and teach you guys today. It's called the color of title. Now, don't get confused. Just because the word color is in there, that doesn't mean markers and Crayolas. It doesn't mean any of that. The color of title is when you have a document. For example, let's say you have some sort of grant deed. You have a grant deed to the land, and it just looks like a normal deed. It looks legit, but the difference between a standard grant deed and something color of title is that there might be some sort of flaw. It might be based on a bad survey. Maybe there's a mistake in the chain of title. However, you have this document that you believe gives you ownership on the property, and you act on it. And that's what the Paines did. When the Paines had that access to that 36 acres, they acted like they were the true owners because they had a deed that they thought was legit, but it was technically flawed. It was a color of title. So even though they had this deed that might have, if you trace it back, not be legit, They still acted like they owned the 36 acres. They built those campsites. They charged people to come in. They made money off of it. And they did that for a long time. They were acting on it. They had all the power. Now, you might be asking yourself, Mr. Big, why does this matter? And it matters a lot. Because the courts love when people have color of title. Because it shows you're not just a squatter. You're operating like an owner. Just like the Paines did. They had full access to the 36 acres and they were acting like they were the owners. It helps prove your use of the land wasn't just some accident. It wasn't some coincidence. You acted intentionally and you have a claim of right. Sometimes it can reduce the time you need for an adverse possession. Now the Paines, they had that color of title. Sexton didn't. So they won. The court looked at the facts and said, yeah, the Paines are acting like the owners. And they had for decades. They improved the land. They ran a business. They had color of title. And Sexton over here, she came too late. She never touched the dirt. She lost. So boom. The title went completely 100% to the Paines. Now that's legal domination. Now, if you're out here thinking you need money to get land, you're thinking small. What you need is strategy. You need leverage. You need to learn how to use the law like a sword. Color of title is one of those swords. Don't forget it. You either learn the game or you get played.